5 ways that estate planning can help your family. Number 1, it makes it clear who is in charge of your estate. Can you imagine someone becomes ill and they're suddenly unable to handle their own finances, or they're unable to make their own medical decisions? And this is sudden. This is a full-grown adult who is in this situation. They have multiple children, and they are in a situation where someone has to take control over their property, make decisions for them. Who is going to be the one to do it? Do you choose the oldest child? Do you choose the child that has the MBA? Do you choose the child who's closest, who lives close by? How do you make those decisions? These are the kinds of things that family members are having to decide just on the spur of the moment when someone suddenly becomes ill and doesn't have a plan in place. But when you have an estate plan, you get to state clearly who's going to be in charge. You get to name the first person in charge. And then if they're not available, second person, the third person. You get to say who's making your financial decisions for you, who's making medical decisions for you, who's going to handle your estate after you die. Is it going to be handled through a will, or is it going to be handled through a trust? You're going to have that clearly stated in your estate plan, so your family's not having to figure this out. And can you imagine what kind of conflicts it could arise where one person says, I'm the oldest, I should be the one who makes these decisions. And then you have the one say, well, I live in the house with them, I'm the one who should have to make these decisions. When you create an estate plan, you put all that in place so your family is not having to figure it out in a stressful situation. Prevents family conflict, confusion, power struggles, and it helps someone to act on your behalf more quickly. You see this family here. What about in this picture? What about if their parent is in the hospital right now and decisions need to be made? Nobody's making decisions because everybody's sitting there fussing and fighting over what to do. But when you have a plan in place, someone can get in there and they can act quickly and make sure that if you are alive and you need someone to make decisions for you, they can do that. Or after you've passed away, they can go ahead and take care of things. One thing along the lines of being able to act quickly, one situation that comes up a lot is if someone dies and their house has a mortgage on it. I don't know how much my family members' mortgages are. I don't know who they have a mortgage with, how much the monthly payments are. I don't know any of that. So if I had to take over for someone instantly, I don't know where to go, where to start. You start calling the mortgage company, they're going to say, who are you? You're going to say, I'm this person. They're going to say, well, do you have power of attorney? Do you have this? Do you have that? These are the kind of things that slow things down and even increase the likelihood that someone could lose property because there's no one in place to act quickly. So number 2, the way that an estate plan can help your family, it keeps your finances accessible and protected. Without a plan, accounts may be frozen. Family members may not be able to access funds to handle your affairs. Have you ever tried to call the bank for like a parent or a sister or brother or anybody, and your name is not on the account? They are not going to talk to you. They're not going to tell you anything. So if you don't have a plan, then your family members may not be able to access money that they need to access in order to either take care of you or take care of themselves. With a plan, you can make sure that somebody has legal authority to pay your bills, to handle matters related to your home, your other property. If you own a business, they can get in there and handle things for you. And if you have people who depend on you financially, they can access the resources they need to live. Let's say that you have a spouse and you have separate bank accounts. The spouse may not be able to get into your bank account unless they have power of attorney. Even if they say, I'm the spouse, the bank's going to say, but your name is not on the account. And this has happened. I've had a situation where I had a spouse who she and her husband, they kept everything separate. And it worked out fine until he suddenly became ill and she was not able to get to his bank accounts in order to pay the bills he usually paid for the family. They each paid their own bill. They each had their own bills they paid from their own accounts. When he wasn't able to get into his account to pay his own bills, She needed to do it for him, but she didn't have legal authority to do it because she was not on those bank accounts. So even with the spouse, it's important to have certain documents in place to make sure that they can access your money easily. We had to, in this particular situation, we had to file to help her to be the conservator over her husband's estate, just so she could access bank accounts. We could have done, someone could have gotten a power of attorney for a few $100s in order for her to have that authority. But instead, we ended up having to do a conservatorship, which was several $1,000s to pay the attorney's fees and then all the other expenses that come with filing the conservatorship. And so when you have an estate plan, your family doesn't have to go through all of those hoops in order to take care of things for you or for themselves if they're dependent on you. And when you have this, it gives your family peace of mind for ongoing financial needs so that they're not left in such an uncertain place. Number 3, it guides healthcare decisions during a crisis. When someone is sick and a decision needs to be made immediately, you don't want them to be in a position, you don't want to be in a position where there's legal hurdles stopping you from making decisions for your loved one. You're in a hospital, you have a sister who's sick, and the doctors are saying, we need someone who has authority to authorize this particular treatment. You don't want there to be a delay. So what you can do with an estate plan is have a healthcare directive in place, which serves as your voice when you're not able to speak. And it allows you to choose someone that you trust to make medical decisions for you. And it will then have the legal authority to make binding medical decisions on your behalf when you're not able to. Imagine the level of stress that it reduces for on your loved ones. They're not in a position where they want to do for you, but they can't. And they get to have clear and defined decision-making authority. The doctors know they can count on that they got the right people in front of them making a medical decision. And then the family knows that they have everything in place to care for their loved one. Number 4, having an estate plan speeds up or avoids the probate process, depending on what kind of estate planning documents you might have. Without a plan, probate can be slow, it can be expensive, and it is public. If you have a will, it's going to be public anyway. If you have a trust, you can make it more of a private process. But either way, without a will, without a trust in place, the process is going to take longer and is going to probably result in higher legal fees and court costs because there's extra things you have to file with the court, and the court is going to have to run things in the newspaper. There's a lot more that has to be done when someone dies without a will versus with the will. And then there are things that if they die with a trust versus with a will versus a trust, there are other things that, could help speed up the process. So with the will, having a will, when you die without a will, someone's going to have to go to the court and say, I want to be the administrator or the representative for this estate. And the court needs to notify all the heirs to make sure everybody's okay with that. And if everybody signs off on it, then the process can continue. But if any of the heirs say, no, I don't want that person to be the administrator, I think I need to be the administrator, that's going to slow things down and is going to result in increased fees for that estate. But you can have your will so it says, this person's going to be my executor. They're going to handle my estate for me. I want to waive any requirements like having to pay a bond, to file inventories, returns to the court. You can say, I give them the power to sell my property and do anything they need to do to handle my estate. These are things you can actually put in your will so that the probate process can be sped up. Or you can avoid probate altogether by having a trust in place and certain beneficiary designations so that your property passes outside of probate when you pass away. So there are different things you can do, different provisions even that you can put in your documents that can help the probate process to speed up or avoid it altogether. But what you want to do is create a plan that helps you to keep your assets moving so that your loved ones can efficiently and clearly know who has the decision. See, I'm sitting here reading my little thing and messing up. I don't know what I was trying to say there, y'all. Basically, if y'all can understand it good, if not, I'm gonna explain what I'm meaning behind that last point there. When you have an estate plan in place, you get to name who's in authority a lot. That you get to say who's going to be in charge and have the authority over your estate. That helps things to move faster. That is going to require fewer checks and balances and roadblocks along the way that will make the process slower and make it cost more money. And finally, number 5, having an estate plan protects your loved ones from conflict and confusion. I think I already kind of said that throughout this presentation, but just in case it wasn't clear enough, an estate plan gives clear instructions about who gets what in your estate instead of it being according to state law. So let's say, just to explain, when someone dies without a will, then the law of intestate succession is going to kick in. What the law of intestate succession is, it is an attempt by the state to say what your will will be. So if you don't have your own will or you don't have a trust in place, a will and a trust, they can be interchangeable depending on how they're prepared. If you don't have either of those in place, state law is going to say, well, we're going to put a list of people who could potentially be the administrator over this estate. We're also going to outline how the property in this estate is going to be divided up. So here in Georgia, the way it works is if you die without a will, your property is going to be split between your spouse and your children, if you have a spouse and if you have children. If you only have a spouse, then they get everything. And if you don't have a spouse, you have children, they get everything. If you don't have a spouse or children, then they're going to see, do you have parents who are living? If not, then we're going to check, make sure your grandparents, see if they're here. If they're not here, then we're going to go to brothers and sisters. From there is nieces and nephews. And then if you don't have any brothers and sisters, no nieces and nephews, is looking at cousins. And they're going to keep going until they find somebody who's related to you. But can you imagine how, like, just uncertain that makes things? You got one house, one car, and now it's going to be split between your surviving spouse and your 3 children. That's usually not going to work unless your surviving spouse and children are, like, your children are minors and your spouse is their mother or their father. But if there's adults involved and there's multiple adults, it's hard to split property up between grown folk. And even with children, if you have minor children involved, as I mentioned before, you're going to have to involve guardians ad litem to make sure that the children's interests are protected. And you also might have to get a conservatorship, because if you open an estate that involves minor children, those minor children can't receive property from that estate. Their surviving parent might be able to if the money is under a certain amount, but if it's over a certain amount, then they might have to have a separate court process be open to open up a conservatorship. And so that just costs extra money, extra time. And we want to try to avoid that, prevent that for our family members. When you have an estate plan, like I mentioned, you get to provide clear instructions about who gets what from your estate, who's in charge. You also get to make special provisions and create instruments for minor children, for vulnerable beneficiaries. So if you have an adult person who depends on you, they have a disability, you can leave things to them in a trust instead of leaving it to them outright, so that you can make sure that someone who's responsible or who can manage that asset can do that on their behalf. You protect your dependents, surviving spouse, and then again, going back to avoiding disputes between your family members and maintaining that family unity. I think that either not having a will or a trust in place, or poorly written wills and trusts, or I would not even say poorly written, but wills and trusts that are created but certain provisions are missing, that can cause a lot of confusion, conflict in families. And I've worked with people who, it's been 30 years since the parents have been gone and the children are still fighting because their parents either didn't have an estate plan or they had one that was set up in a way that kind of made it automatic the people were gonna fight. So like one of those situations would be naming all your children as co-executors. You got 3 kids and you say y'all gonna all be co-executors and I want y'all to work things out. Now those parents have good intentions when they do that. But if the kids couldn't figure out who was gonna be able to play the Nintendo first, then they're probably not gonna do a good job of handling your estate together. So just thinking about those kind of things when doing estate planning, making sure that you are setting your family up for continued harmony and success after you're gone. Now, I know I had a question or two. Oh, I figured out. Okay. I had a question or two earlier, so I just wanted to make sure. So I did want to just address this question. Say, if my spouse has an estate plan, I do not, how would that affect our joint assets if one of us passes away before the other? So to answer that question, it really is going to just be a matter of what the different plans, how they're set up. For the person who has an estate plan, their estate plan is going to control their part of the property that's owned jointly. For the person who does not have an estate plan, state law is going to determine how their part of the estate is handled. So when you own property jointly with someone, then you each own a portion of that. And whatever planning you have in place or don't have in place, it is going to be it's going to be directed. How do I say this? Whatever you have in place, that's going to determine how your part of the assets are handled. So, for example, if a married couple bought a house together and it's set up so that it's not a joint tenancy with rights of survivorship, when it's a joint tenancy with rights of survivorship, that means if one spouse dies, the other one automatically gets full ownership of the house. If it's not set up that way, that means that both parties own one half of an interest in the property. So when one of them dies, their half is going to go through their estate. If they have an estate plan, that estate plan is going to dictate how their property is handled. If they do not have an estate plan, then state law is going to determine how their part is handled. So that's how it would work. Whether if both people have an estate plan, then both estate plans are going to impact both halves of the property. And if one does and one doesn't, then state law is going to affect one half, and then the estate plan of the one who had the plan is going to impact their half. That's why I always encourage people when they are married to create an estate plan that works with each other. You don't necessarily have to do your plan at the same time. You don't have to work with the same lawyer, but it's good to try to make sure that your plans work together so that one spouse is not left out of the process in a way that is not going to be beneficial when it's all said and done. So we're going to talk a little bit about some misconceptions, and then we're going to talk about the process of estate planning and just some things to keep in mind when going through that process. So common misconceptions. I don't have enough to require an estate plan. Everything will go to my spouse and kids automatically. I already have a will. Shouldn't that be enough? So with number one, I don't have enough to require an estate plan. I always tell people, I don't care what you have. If you got $1 million or you got $100, you need to have an estate plan in place. Now, the type of estate plan you have may be different, but you need something. At a very minimum, you need to have a financial power of attorney and a healthcare directive. Both of those documents terminate when a person dies. They don't have any bearing after the person dies. But it's important that if you are ever sick and then you need someone to handle your finances for you, having a power of attorney in place is going to help, like we talked about before. Having a healthcare directive is going to help someone make medical decisions for you if you're not able to. So even if you don't own anything, you need to have those things in place to take care of you if you can't take care of yourself anymore. Even if all you get is Social Security. Let's say that for some reason your Social Security check doesn't come in this month. Does someone have the legal authority to call the Social Security Administration on your behalf and say, hey, what's going on with this check? So even if you don't own anything, you need to have some sort of estate plan. And I recommend to go ahead and take the extra step of having at least a simple will, because that way, if something were to happen to you and you, or when you die, you may not know that you actually are entitled to some assets at the time of your death. So the situation I mentioned before at the beginning when I was giving the story about my client, um, in this particular situation, someone died without any assets, but one of the family members who died just before them actually had an insurance policy that they paid out to that person who died without thinking they had assets. They didn't know that someone was going to die a few days before them and leave them a significant insurance policy. Another situation that came up was where someone died in an accident and they didn't own a house, they didn't have bank accounts, they didn't have much at all, but the accident created a legal claim and someone had to file that legal claim on behalf of their estate. We were able to go to probate court and get an administrator appointed over their estate, but it would have been so much easier if they had just a simple will that named an executor, and that would have allowed us to probate that will and name someone over their estate. So there are things that happen that you don't even know could happen. And so it's good to have at least a very basic estate plan in place. Now, if you got more assets, you might need some tax planning in your estate plan. You might need to have some complex trust involved and multiple trusts involved. But you got to create the plan that's going to be right for you. So I think no matter what you have, even if you consider it to be very little, it's still enough to require an estate plan. Another thing, like I said, everything will go to my spouse and kids automatically. That is true in many ways, but it may not happen in the way that you want. A lot of times when people are married, they would want everything to go to their spouse first so that their spouse has everything they need. And then the kids can be taken care of later, especially if those kids are older. But it doesn't always work out that way. I actually was having a conversation with someone yesterday where they assumed that the surviving spouse would get everything, right? But no, the children get a portion as well. And the way it's distributed is not in a way that's always going to make sense. The spouse might get 1/3 of an interest in the house, and then the kids get 2/3 of an interest in the house. And I don't know about y'all, but I don't want to live in a third of a house. Like, I want the whole house. So you really have to create an estate plan to make sure that things go to your spouse, to your kids in the way that makes sense for you. You might have some kids who are minors and some who are adults. You may want to make sure that the minor children get more of your estate so that they are not left in a position where they can't even grow up with enough resources. You might have the adult kids, they got jobs, they have resources, and so you want things to be more available for the younger kids. So you want to make sure your estate plan is going to make that you have an estate plan in place and that is designed to be appropriate for you. And then finally, I already have a will. That's enough. For some people, a will is enough. And for some people, they might want to consider something like a trust to give them a little bit more control over how their assets are structured. And also, a trust can offer a quicker administration of your estate. It can offer more privacy. There's so many more options available to you when you have a trust. And so I wouldn't assume that just because you have a will, that would be enough. In some cases, it is plenty, but in some cases, a trust might be more sufficient. Another thing to keep in mind is that you might have a will, but if you did that will 30 years ago and your whole life is so different, then it's time to do an upgrade, to do a what we call it? Update. It's time to do an update. So just think about these things in this conversation as well. And I do still welcome y'all to ask any questions that you may have. If I can help, then I would be happy to do so. So how to get started? I like to encourage people to view estate planning as a gift. So I want you to establish your goals, create an inventory, select your fiduciaries, and assemble your team of advisors. Establishing your goals, just like Stephen Covey said, begin with the end in mind. I want you to think about your life and think about where you want things to be at the end of your life and for those who are going to still be here after you're gone. Go ahead and cast that vision. And you can do that through your estate planning so that those that you are leaving behind, your beneficiaries, can pick up the torch and leave off where you leave. They can pick up where you left off and keep running. Boy, I tell you, sometimes my reading skills be a little tricky on me, but they can pick up the torch where you leave off and keep running. You don't want your children having to start over after you're gone. And I will say, when we're doing estate planning, usually we're not really planning for our children as much as we are our grandchildren. So you want to leave something for your grandchildren that they can actually build upon and then continue that family legacy. Or maybe you don't have children or grandchildren and you want to leave things to your nieces and nephews or kids in the community that you come from or that you live in. There are so many ways that you can help others to have a leg up that you didn't have because you have an estate plan in place. So I want you to really think about what your goals are. Everybody in here is going to have different goals. And so that's going to help drive your estate planning process. Create an inventory. Make a list of everything you own. And if you're not ready to actually make a list, just start gathering documents. Where are all of my deeds? Where are all my bank statements? The signature card for my bank statement. Do I have a pay on death beneficiary set up for my bank accounts, for my investment accounts, for my insurance policies? Do I have beneficiaries set up? I keep forgetting to change this. I do a lot of presentations for farmers, so they might have farm equipment. So if you got farm equipment, make sure that's on your inventory list. Or if you're a business owner, you might have assets from your business that you want to make sure are accounted for. Any vehicles, valuable personal property. Go ahead and take some time and think about what you own. And one thing I like about estate planning is you put all this stuff together and you might be like, I actually wanted to accomplish a little bit more in my lifetime. So it's a good time for you to really take stock of where you are and see, do I want to do more? I know me, I'm thinking about things. I want to get more investment properties. I want to buy some more assets. I might want to invest in other things as well. So this is a good time for you to take inventory of what you're already doing and then think about what would I like to add to this profile to make things even more beautiful and more abundant when I'm getting ready to transition this over. Select your fiduciaries. So these are the people who are in charge of making your estate happen. These are your executors, trustee, legal guardian for your minor children. If you have someone who's incapacitated, or even for yourself, who would be legal guardian or conservator for you if you became incapacitated and unable to handle your own affairs. Who would you have as your agents? Your agents for your healthcare decisions, your agents for your power of attorney. Who do you want acting on your behalf for your estate? And then finally, assembling your team of advisors. That's going to include your estate planning attorney, your CPA, financial advisor, insurance agent. If you own land, your land use experts, business consultants. Start thinking about who you want on your team to be advising you through this process. You may look at this list and say, I don't want to have any of these folks involved because I'm not at that level at this time, but at the least, I do encourage you to have an attorney to do your estate planning, because there's so many pitfalls that people don't think about, don't know about, that attorneys who are experienced in estate planning, which is important. Don't get your personal injury cousin to do your will. Go ahead and get an estate planning attorney to do your will. But there's so many pitfalls that they're thinking about that you, as someone who's not an attorney, it's just not going to know about. And it's no not to anybody, but it's just what we're studying is how to help people with estate planning. And these are things that do take a lot of time and attention in order to make sure that you are up to date on the law. I learned something new the other day. there was a provision in a will that I thought should accomplish a particular goal for my client's parents' estate. And when I talked to the court about it, they said, the law changed and now it requires XYZ. And that's something that even I didn't really realize had that kind of an impact. It's like you don't always see it until you actually see it play out in real life. So it's those kind of things that having an attorney who's familiar with this kind of area can be very helpful. So talking about getting started with my firm, what we do, we start with a legacy planning session. And that session is $400. If you hire our firm, then we will apply that $400 to the total fee for working with us, particularly since you are participating in this webinar. So you would complete an intake form, and then after you complete that intake form, we'll have a meeting and we'll discuss which package we offer that will meet your estate planning goals. And we're not just going to be like, all right, here, yes, get this is going to be the price, but we're actually finding out about your family, getting a clear understanding about what your goals are, what your needs are, and how we can assist you with your estate planning. A lot of people find this initial conversation to just be really helpful because the stuff we talked about today is not going to just be general information. It's actually like your particular family situation. So if you are interested in that, then you can, we'll have the information on the next slide on how to reach out to our firm. If you still have questions and you don't think you're ready to schedule a legacy planning session yet, then you can reach out to our firm and we can schedule a quick call just to like tie up any loose ends that you may have that you need to have answered before you feel comfortable scheduling the full session. So here's the information to get started with us. And, just feel free to, I don't know where that QR code is going to take you. So if it takes you somewhere that you're not ready to take action there, I can't remember which page it goes to, then you have other ways of contacting us, and you can just respond to the email you got about this webinar if you have questions. We are here to help. My website, McClendonLawOffice.com, has a lot of information on how to reach out to us and more information about our firm. But either way, we'd be happy to talk with you to help you get started, whether it's scheduling a legacy planning session now, or if you need to have more information, then we can schedule a call for you to get more information. And we also can have you join us on a future webinar. So with our firm, just so that you know, we offer personalized plans. These are not cookie cutter plans. We are offering plans that actually fit your particular situation. And we have as many meetings as we need to help you to get ready and make sure that we're creating a plan that's going to be most beneficial for you and your family. Our pricing, we use fixed fee pricing. We don't charge by the hour when it comes to our estate plans. So when we do the legacy planning session, we'll be able to tell you specifically how much it will cost for getting the plan that you choose with our firm. We like to have family-centered conversations, making sure that you're looking at all of the different angles when you're doing your estate planning. And for me and my team, we are experiencing this, and we are going to be providing patient guidance every step of the way. I've had people who don't want to start because they're like, well, I feel overwhelmed. I don't know where to start. I don't know what decisions to make. And I'm just like, that's what you hiring us for. We're here to help you through this, and help you to get whatever information you need or resources you might need in order to feel confident in the plan that you are creating. So I would love to talk with you all now about any questions that you may have and what might be holding you back from getting started. Like I said, I'm going to stop all the recordings and everything along those lines so that you can feel comfortable asking questions. I do ask, though, that you are mindful of your own privacy. So don't tell people, don't ask questions on here that you don't want everybody knowing your business.